Hello and welcome. Today, we're going to unpack one of the most serious and complex offenses in South African law, the statutory crime of terrorism. So let's dive right in. Here's our game plan. We'll start with a bit of context, why we study crimes in this particular order. Then we'll get into the real heart of it, what I like to call the legal recipe for terrorism. We'll break down all the ingredients, see how they work in a major real-world case, and then we'll wrap it all up with the key points you absolutely need to know. Okay, first things first, let's set the stage. It's really important to see how a specific crime like terrorism isn't studied in a vacuum. Nope, it's built directly on those general principles of criminal law that you've already been working on. So, you might be wondering, why do we bother with all those general principles first? Why not just jump straight into the exciting stuff like terrorism? Well, the truth is, you simply can't. Those general principles, legality, conduct, unlawfulness, and culpability, they're your essential toolkit. Without them, you can't properly take apart and analyze any specific crime. It's a logical process, you see. First, you master the general principles. Then, to make sense of the thousands of crimes out there, we group them into categories based on what they're trying to protect. For instance, some crimes protect your property, others protect your physical safety. Only once we have that context can we really dig into a specific offense and understand what it's all about. Now, terrorism fits into a really special category, crimes against the state. And this is where the focus shifts dramatically. We're not just talking about protecting one person from another, like in a case of theft. We're talking about protecting the entire collective, things like national security, our whole constitutional way of life, and the very stability of the country. Now, of course, we have the old-school common law crimes against the state, like high treason and sedition. But the world has changed, and our law needed a more modern tool to deal with modern threats. And that tool is the statutory crime of terrorism, which came into effect back in 2005. Today, it's really the main legal weapon in this area. Okay, let's get to the core of it. The legal definition of terrorism in the Act is, let's be honest, incredibly long and complicated. But here's the best way to think about it. It's like a recipe that has 3 essential, non-negotiable ingredients. And this is the most important part of the whole recipe. There are exactly 3 components. The prosecution has to prove every single one of them. If they fail on just one, the whole charge of terrorism falls apart. It is completely an all-or-nothing situation. So, what are these 3 magic ingredients? First, you need some form of serious conduct. That's the act itself. Second, you need a very specific intention. That's the aim, what the person is trying to achieve. And third, you need a specific purpose. That's the motive, the why behind it all, which must be political, religious, ideological, or philosophical. The act, the aim, and the motive. Remember those 3. All right, we have our recipe. Now, let's put on our legal hats and deconstruct each ingredient. We're going to do this by linking them back to those general principles we talked about earlier: conduct, unlawfulness, and culpability. So, first up is conduct. The definition here is incredibly broad on purpose. It covers the obvious stuff, violence and explosives, but it also includes things like releasing chemical agents, causing massive property damage, or, and this is super relevant today, interfering with essential services like the banking system or telecommunications. The law also makes it clear that this conduct can happen anywhere in the world, not just inside South Africa. Okay, on to our second element, unlawfulness. Now, this is absolutely critical. Just because an act looks like the type of conduct we just discussed, it doesn't automatically mean it's terrorism. Think about a lawful protest. If some property gets damaged, that might be a crime, like malicious damage to property, for sure. But it isn't terrorism unless that specific aim and motive are there. Our Constitution fiercely protects the right to protest and dissent. An act can also be found to be lawful because of a ground of justification. A classic example is compulsion. This is where someone forces you to do something illegal by threatening you with serious, immediate harm. So imagine someone holds a gun to your head and forces you to drive a car full of explosives. Your actions might technically fit the definition of conduct, but your conduct wouldn't be unlawful because you were compelled. And that brings us to our third and arguably the most defining element, culpability. For terrorism, this requires a special kind of 2-part intention. It's not enough to just do the act. The state has to prove, 1, that the person intended to intimidate or threaten a government or the public, and 2, they must prove the act was done to advance a political, ideological, or religious cause. You can think of it as the aim versus the motive. Both parts have to be there. Now, when we talk about intention, it's important to know that dullis eventualis is enough.
Okay, legal jargon alert. All that means is that the accused didn't have to directly want the terrorist outcome to happen. It's enough if they foresaw it as a real possibility and went ahead with their actions anyway, reconciling themselves to that risk. And remember, a court can figure out what was going on in a person's head by looking at their actions and all the surrounding facts.
So we have the theory down, but what does this look like in practice? Let's turn to a really important case, State versus Okah. It does a fantastic job of showing how these rules apply, especially when terrorism crosses borders. So here's the story. Henry Okah was a Nigerian citizen, but he was living right here in South Africa. From his home, he planned, he funded, and he coordinated 2 car bombings that then took place in Nigeria. So the bombs went off in Nigeria, but the mastermind was in South Africa. And he was prosecuted for terrorism right here.
This case went all the way up to our constitutional courts, and their decision was a real game changer. The court said, look, terrorism is a global problem. It doesn't respect borders, so our laws can't stop at our borders either. They confirmed that South African courts can prosecute someone for terrorism even if the final act happens in another country, as long as a key part of the crime, like the planning, happened here. This was a massive step for international cooperation against terrorism.
And just as a final note on the law itself, it's worth knowing that the act doesn't just criminalize the main act of terrorism. It also created a bunch of related offenses, like hiding a terrorist, failing to report one to the police, or even just creating a terrorist hoax. It's designed to be a pretty comprehensive piece of legislation. Okay, we've covered a lot of ground. Let's pull all those threads together now and focus on the most important takeaways so you know how to apply this framework. So let's recap that 3-part recipe one last time. First, you have the conduct, a serious, harmful act that's defined very broadly. Second, you have unlawfulness. The act can't be justified, and this is where we exclude things like legitimate protest. And third, you have culpability, that critical 2-part mental element, where you need both the aim to intimidate and the political or ideological motive.
And that leads me to my final and most important point. If you take just one thing away from this, please let it be this. Do not try to memorize that massive, complicated definition in the Act word for word. That is not the key. The key is to understand the 3-part structure. Your success will come from applying that framework, conduct, unlawfulness, culpability, to the facts of any problem you're given. Master that framework, and you will be able to handle anything this topic throws at you.